Oh, Tay, we are live. Zach, how are you doing, buddy?
I'm good, Aaron. How are you?
Doing excellent. Okay, so we're still on verdict watch, but I didn't want to clickbait everyone and say that we're literally on verdict watch because that's not why we're doing this stream. We're doing this stream to dig into this amazing. Oh, hold on.
No, you're good. Go ahead. I got you. I
We're
got it
good.
now.
We're doing this stream. Yesterday, in the stream that we did, we talked about this amazing exhibit that defense attorney Philip Cohen did called The Scale of Guilt. And you said guilt is like being pregnant. You either are or you aren't.
Correct.
And one of my viewers sent me an excerpt of the notes that Tony Ortega had published describing this chart. And so I read it. I sent you a copy of the description. I want to read this to the viewers, and then
Sure.
I want to tell you as just a layperson what goes through my head, and I want to discuss this.
Sure.
Okay. So, so Philip Cohen, it says he shows a chart. It goes through the stages about how you're feeling about the evidence in this case. It goes from the bottom, and the bottom of this scale is proven not guilty. And remember, Miss Goldstein and I could have done nothing and not asked a single question. The presumption of innocence starts here at the bottom of the scale, and it goes up the ladder. He may be guilty, maybe not. That's the next step up from the bottom. He may be guilty, maybe not. If that's the mindset, it's not even close to proof beyond a reasonable doubt. You're working your way up the ladder. I guess he calls it a ladder and a scale. The next step up the ladder is you think he may be guilty. The women took the stand. They all said what he did. I think he may be guilty. And he goes, you know what? You know what that requires? A not guilty verdict. The next step up the ladder is he's probably guilty, but that means nothing. Further up the ladder, his guilt is highly likely. Again, that requires a not guilty verdict. It's only if you get to an abiding conviction, the most compelling, the most thorough feeling I could have, that man is guilty of what he's charged. That and only that is proof beyond a reasonable doubt, regardless of what you may think of anyone in this trial. And then the person who sent me this excerpt says, if this is the scale the jury was asking to get another look at least this viewer didn't take that as a good sign. Now, I have some questions about all this, but what's your take right off the bat? What do you make of this?
So I agree with the approach up until he uses the word abiding. He did a fantastic job of explaining these levels of doubt, essentially, up until he says, up until you get to abiding. You've lost the jury. You've had a really simple terms, and then you hit them with the big word. It's not an insult to the intelligence of the jury, but there's a cadence, and it's just a stylistic thing. There's a cadence and a rhythm at which we speak, and if you look.
Zach, I just lost you, and it says you're muted. I think you might have accidentally hit the mute button. It keeps toggling back and forth. Nope, I can't hear you. Stick with us, guys. There you go.
Can you hear me there?
I can hear you now, although it's a difference in quality. But yeah, did something
Yeah,
happen?
I had to switch to the default microphone on the webcam, so it's not going to be as good as what I had. But
this will be okay.
Okay. I don't know. I've got to troubleshoot some systems apparently. And so you had me right up until, or he has me right up until he uses the word abiding. I would use a different word, a different cadence. But essentially, what he's showing, what he's attempting to argue, and if you're the defense attorney, this is the argument you have to make. You don't have a choice. That beyond reasonable doubt is a functionally impossible standard. If I was giving the argument, I would give it a different way. And here's the way I would make the argument, just because we're here. Part of the screening process in selecting you as you individuals to be on our jury was to determine whether or not you think like a reasonable person would think. And if we didn't think you're reasonable, if we felt like any of your positions or views or stances on life were unreasonable, we would have asked the court to dismiss you. But we didn't, because you're a reasonable person. Reasonable people don't have unreasonable thoughts. And if you have any thought at all, any concern at all, that Mr. Masterson didn't do this, that's a reasonable doubt, because reasonable people don't have unreasonable doubt. That's the way I would make the argument.
Mm-hmm.
I don't know that it's any more or less powerful, but that's the way I would make it.
Right. I'll tell you what was going through my mind when I was reading this scale. And you sort of touched on it when you said beyond a reasonable doubt is actually kind of an impossible standard. I didn't misquote you there, did I? That's what you said, right?
No,
Yeah.
you're right.
What occurred to me is that people do not think in those terms. Beyond a reasonable doubt. I mean, what about beyond unreasonable doubt? And like I'm talking about, there's this funny Chappelle skit where the joke is that a certain, I'm going to use careful words here. The joke David Chappelle was making is that a certain demographic would not find O.J. Simpson or R. Kelly guilty, no matter how much evidence there was. And there's this funny skit he does where they keep showing you the most absurdly concrete evidence. And they're like, I don't know. That could be anybody. Like it was funny. But the point is a juror could have unreasonable doubts where they don't want to find this person guilty, no matter how convincing the evidence is. Right. But anyway, I'm kind of making my counterpoint. It occurred to me that even when I was on a jury, when I served on a jury, I wasn't really thinking in terms of beyond a reasonable doubt. And all that really matters is what the jurors are thinking. It doesn't even matter what the law says they should be thinking. It's what are they really thinking in the real world? And do people even really think that way? Because when he was describing this scale of justice and he started getting up towards the higher rungs of the ladders, I couldn't help but find myself thinking, oh yeah, I'd convict a person at that level of evidence. Like, so for example, one of the things when he goes up the ladder, he's probably guilty, but that means nothing. Up the ladder, his guilt is highly likely. I find myself going, yeah, highly likely means guilty, but highly likely doesn't mean guilty.
It doesn't, and this is where I think it can get lost a little bit in the weeds if you're the jury. And this is exactly why the judge says this isn't evidence. Right? Yesterday, the jury requested, the judge said you can't have it. That's not evidence, because the jury would place improper weight on that, because what they were trying to use that for was an explanation of the law. That's not how the law works. The law is what the judge tells you the law is. Right. And so since that's not the law, they can't use that to interpret the law. And that's what they wanted to do with it. That's why they can't have it. That's the only argument you can make if you're the defense attorney here, is that if you have any doubt at all, it's reasonable doubt. And functionally, the standard the state has to prove is impossible. But the state, and I didn't read real close the notes about the state's rebuttal clause. So the state is the party who has the burden to prove. They get to speak twice. They get to give their initial close, and then they reserve time for the rebuttal close. The defense gets to make their statement, their argument, and then the state gets to rebut that and address some things. And so it's sort of a strategic thing. We leave a little bit out, save it for the end, so there's always something to go to the table with. And then we fill in the blanks with what the defense raises in their closing argument. And you have to take it to the defense attorney, or if you're the prosecutor rather, you have to take it to the jury and say, we're not asking you for an impossible task. If it was impossible, there would never be convictions. And we all know that people do bad things and we put them in prison for it. This is the same thing that happened here. This is not an impossible burden. It's a high burden, but we've satisfied it. And here's why.
Right. I did see in some of the notes that Tony Ortega published at the end of the day last night that as the jurors were coming out of the room, there was a definite look of frustration on some of the faces. To me, that indicates someone is stubbornly holding out. Is that, what would you make? Do you read much into that?
So I don't know that it's somebody stubbornly holding out. They could also be frustrated with the pace. There may be 3 or 4 people who've made their minds up, and there's the rest of the group. Maybe they're not in opposition, but they say, we want to look at this evidence. We agree with you, but we want to make sure, right? So it could be the pace at which they're getting through the evidence and the witness testimony. It could also be the frustration with, for all, again, speculation, it could be frustration with, Danny Masterson or any of the attorneys. We're frustrated that this argument was made because now somebody's given it weight they shouldn't. We all agree about this, but somebody's not confident enough to sign the papers yet.
Right. One of the questions the jury asked today is they wanted to hear again the portion of the testimony where Jane Doe 1, she'd suffered her attack. She went on a trip to Florida, and at some point during that trip, she called Danny on the phone and had some conversation with him. That call was not recorded, but they wanted to hear her testimony about that call again. That seems like these guys are really far into the weeds on this. I didn't know what to make of that.
So what it probably is, so they were allowed to take notes. Everybody takes notes differently. Everybody remembers things differently. I could have 10 witnesses observe the same thing and get 10 different statements, only 8 of which are remotely accurate, right? So they look at their notes and somebody says, well, I know exactly what it said. Somebody else said, no, you're wrong. They said this. Well, if we have a question about what it says, we can request that we have that part of the testimony read back to us. And then we know exactly what was said because the court reporter is taking it all down word for word. And that eliminates any of the confusion amongst the group.
Right. So, well, when it comes to the scale of justice here, I don't know that I had any more questions specifically on that. When you said abiding conviction, and I remember you said you had a problem with that wording. You thought that he made a mistake by getting too technical, like just not using simple enough words? Because I mean, abiding's not a very complicated word. What was your question there?
Here's what I mean by this. When I was reading Tony Ortega's notes and, you know, the rough transcript that he does, and to be honest, I'm pretty impressed with his ability to transcribe some of that in real time. That's really quite tough to do. Court reporters have a special machine that does that using phonetic spelling, and it's quite impressive. So the fact he's done it is pretty impressive to me at all. But that issue aside, that notwithstanding, the average person, I'm only going to have their attention span, even an adult, I'm only going to have their attention span for 20 to 25 minutes. Which means if that's a 2 or 3 hour closing argument, I'm only going to have the entire jury for about 25 minutes. Throughout that 2 or 3 hour argument, I'm speaking to different members of the jury. Sometimes I can clearly tell who I'm talking to, because there's some dude in the front row doing this. I'm clearly not talking to him at that point, right? And so the way that we keep people's attention on these extended discussions is things like pace and cadence. If you think of a hip hop rapper, a hip hop artist who's performing a rap song, there's a cadence and a rhythm, and you see the people dancing to it, clapping to it, chanting to it. With musicians' songs, it's the same way. When you listen to a really good speech giver, and I'm going to go back to the old show called The West Wing from the 90s and the early 2000s. The screenwriters did a great job when writing for the president speeches with a cadence and a rhythm. And every speechwriter does that. That's why, regardless of your politics, everybody watches the president speak. And for the most part, the speeches, even if the speaker's not good, the speeches are good because there's a cadence and a rhythm. And we keep people's attention by keeping this cadence and rhythm. And when I was listening to you read what you read, there was a natural cadence and rhythm to it. And then all of a sudden, it's sort of this long soliloquy of fairly simple words, fairly simple sentences in a storytelling tone. And then he hits you with this 3-syllable legal word sort of out of left field. And it broke the momentum and the tempo of the closing argument, and not in a good way. You sort of, I call it the bobblehead effect, right? The Mike Rinder bobblehead. When I'm giving an argument and I want the jury to agree with me, I'll get my head nodding, and I want 12 heads nodding with me. If I'm trying to refute something that was said, no, that's what the witness said, but that wasn't true, and you know it. I'm going to get that head going, and I want to see 12 heads nodding with me. Right? It's sort of this subliminal, yes, he's right, no, they're wrong. I want that body language, and if I can use rhythm and cadence, it helps me keep that. So it's just a stylistic thing. I don't know that it's a bad decision, just stylistically, it's not the way I would have approached it.
I get it. That makes sense. Here's a comment from Deviant Outcast. Beyond reasonable doubt is actually a kind of manipulative phrase. It sounds very specific, but the truth is there's no absolute general standard for reasonable. I mean, that's a good point. What is the definition of reasonable doubt, really?
And this is the entirety of the practice of law in any capacity, right? In civil law, so lawsuit-based law where there's no criminal outcome, it's money damages, the standard is a reasonable person. What would a reasonable person do? A reasonably prudent person? Well, the law argues, and has really since we broke off from England, because we have a common law history going back to the colonial days. Reasonable is a subjective standard, and it needs to be, because My definition of reasonable as it pertains to tractors may be different than your reasonable as it pertains to tractors if you have no experience with tractors, and I've been on a tractor my entire life. The way a reasonable person drives is going to vary based on, are we on the 405 or am I a NASCAR Cup driver at Daytona, 3 deep in the draft, driving 200 miles an hour? What's reasonable is subjective to the circumstances. So we can't set a concrete standard because we're never going to see the same set of facts twice.
That makes sense. That makes sense. I see some comments and some questions here regarding Jane Doe 1, 2, 3, and 4. And I want to comment. I have heard through the grapevine that Jane Doe number 4 was very upset with the content of our conversation on yesterday's call or on yesterday's video that we did. And I want to make something clear. I was not calling into question anything about Jane Doe 4's testimony. By the way, Jane Doe 4 is not one of the named victims in this case. She's a witness. She's not one of the victims the jury is deliberating about. We're here in speculation land on Jury Watch, and our whole role here is to put ourselves into the shoes of the jurors and try to understand what they may or may not be thinking, or what could be leaning them towards acquittal, what could be leading them towards conviction. And if all we do is sit here and pretend like the only possible outcome is conviction, we're being kind of idiots, because that's not the way the world works. So it's just sort of intellectually honest to consider some things. I wasn't sharing my thoughts and beliefs about Jane Doe 4's testimony. We were discussing a comment that was shared by someone else who was in the courtroom. And it's really just a bunch of mental masturbation that we're doing here. I hope YouTube doesn't ding me for that. So no offense was intended. And I fully believe Jane Doe 4, everything that she said. And we're just having discussions, folks.
Well, and I didn't say that at the end of yesterday's video, but I did say it at the end of the video before that. Every one of these individuals who stepped forward and made allegations, whether they're alleged victims or in this case Jane Doe 4, who has made allegations, I believe those. I have no reason not to, especially considering the behavior that's been promoted and the fact that there seems to be some consistencies across the behavior. So I have no reason to doubt Jane Doe 4. And although her identity is known, I don't watch a ton of movies, so I wouldn't recognize her if she walked in the door and introduced herself. I wouldn't know her from Adam. So I've never seen this individual, wouldn't recognize her if I saw her. So I have no reason to doubt her either. And if she was upset by that, that was certainly not our intent. I can assure her of that.
Yeah. And I don't doubt her. The fact is, if we all just sit here and go, there's only one possible outcome, then, well, that's kind of a waste of time. Okay, so that is everything I was wondering about this scale of guilt. And other than that, I don't know, we might, unless we get some notification that, we have a verdict, I don't think we're going to get one today. Have you been keeping your eye on Twitter?
I have. The most recent update was so earlier this morning. I think they're at lunch break still, or maybe you're just coming back from lunch. They did have, and you had talked about the one question the jury had today was the readback of that portion of the testimony. And I do know, since we're here, I don't know what your hard stop is, where we are on time, but I know you had a couple of questions about the Paul Haggis trial, and there were some comments asking if you had those questions or not.
What?
And we had a live, but we didn't get to it because I had a hard stop or something, I think.
Oh, from previous. I think, okay, so here's a question. Why is it that by the way, Paul Haggis was found guilty in the civil trial of what he was being accused of. There was no proven.
So for your viewers, the term we use for that in the civil world, we would call that civilly liable. He was found liable for the misconduct of which he was being sued. It's a nuanced thing. I know what you meant, but guilty, we reserve that specifically for the criminal world. In the civil case, you're either liable or not liable. It's just splitting hairs.
Okay, so guilty, not guilty is strictly criminal, technically speaking?
Yes.
Okay, cool.
And so then liable, not liable is everything else.
Okay, good. There was a part where I guess she ended up being the plaintiff when originally she was the defendant. No. So what's the official word? You wouldn't say plaintiff and defendant, would you?
Yeah. So the plaintiff is the person bringing the suit.
You would still say that.
Okay. Is the person against whom the suit is brought.
Okay. She was seeking unspecified damages. And one of the questions I had is, why is she allowed to not specify? I mean, this is really in the weeds, guys. This was a question I had before the verdict came out. But why would she be allowed to not specify how much she was seeking? Wouldn't that maybe factor into whether
So
the
it's going to
motivation?
It's going to be jurisdictionally specific, but it would make perfect sense to me why they do that. In Oklahoma, for example, and I use that a lot because that's my primary state. I'm also admitted in Colorado and some other federal courts for the viewers who weren't there for that video. But so one of the things is this: it is in Oklahoma, if I allege that you injured me or my property and I'm entitled to compensation, and I seek an amount less than $75,000, I have to specify to the penny how much. If I seek a value greater than $75,000, I just put unspecified damages in an amount exceeding $75,000. If the jury comes back and gives me $1, it's okay. If they give me $1 million, it's okay. But I'm going to claim greater than 75,000 so long as I have a reasonable basis, which is a really broad standard, right? The reasonable standard again. As long as I have a reasonable basis to believe that a jury would give me $75,000 and a penny or more, I can claim it. And what that does is, if I ask for $100,000 and then something along the line comes up and I discovered this case just tripled in value because there were drugs or guns or violence or something, the value of this case just tripled, I'm limited to the $100,000 I sought unless I amend my request, called amending the pleading. And then instead, I asked for unspecified, and then at closing argument, I put up to the jury, here's how much I think this case is worth and why, and I give them a fiscal breakdown. But that number can move based on testimony during trial, and then I pick a value at closing arguments and support it with evidence.
I got it. That makes sense. I see a question here. Well, I clicked on the wrong one, but yeah, here we go. Can Paul appeal? Yes, and he's already stated that he will. He said, "Look, I cannot." He said, "I will." He said, "I will die trying to clear my name before I will live with this lie." I've been careful on how I covered or spoke about that case because I know that the victims in the Danny Masterson case are victims of Danny Masterson. I don't know that Paul didn't do what he's accused of. I don't think he did. I hope he didn't, but I don't know that he didn't. And so I'm not going to pretend like I do.
Right. So this is something that I think your audience needs to understand. We saw this in the OJ case way back in the 90s. It is much easier to sue somebody and win civilly than it is for the state to prosecute them and win a conviction. Because the standard in a civil case, in the Paul Haggis case, rather than beyond all reasonable doubt, which is what the Masterson case standard is, it's called a preponderance of the evidence, more likely than not. If all things are equal, all I have to do is tip that scale ever so slightly in my favor and I win.
Right.
More likely than not, if I flip a coin 10 times, is it one time more than not likely to land on heads or tails? That's fairly easy to satisfy.
Right. I'm not sure what this means, but here's a comment. Judge will give depth charge Friday late AM. Do you have any guesses as to what that means?
I've got a couple of guesses. I've never heard that term, the depth charge. Somebody in the comments yesterday, by the way, last night, did remind me that the charge where the jury gives, or where the judge gives the jury go back and reconsider, is called the Allen charge, and it's based on the State versus Allen or whatever it was. And so whoever that commenter was, I appreciate that. That is correct. It's called an Allen charge. If they're referring by the depth charge to the Allen charge, that may be, hey, if they come out with a note that they're hung, that may be what they're referring to. I've never heard of the term depth charge specifically, but there's a lot of shorthand slang in various jurisdictions as to what that charge goes by.
So quo vadis or quo vadis, however you say that, if you want to clarify that question, I'll try to keep an eye out for it. The other question that I would have asked at that time is, Paul Haggis's defense team was not allowed to introduce the information that Haley Breest had through her lawyer and contacting Paul's lawyer. Basically said, I'm going to give me $9 million or I'm going to file these charges.
Yeah.
He wasn't allowed to bring that up, even though that seems a little more relevant than honestly Scientology's role in this case. Scientology's role was completely circumstantial.
Right. So here's the thing about those, no matter how ugly the wording is, or no matter how eloquent the wording is, that is an offer of settlement. Offers of settlement are not admissible because the jury can theoretically, if I sue you and your lawyer, your insurance company, whoever says, hey, I'll give you $10,000 nuisance money to go away. It's cheaper for me to pay you $10,000 than to pay a lawyer $80,000 and defend it. And then if I introduce that at trial, the jury says, well, it's got to be worth at least $10,000 because they already offered to pay him. So offers of settlement are never admissible for that reason.
That makes sense. That does make sense. And I almost hate to put it this way, but if she was demanding $9 million in the beginning and the jury, including punitive damages, you know, find him liable for $10 million, in some respects, it was still worth it for Paul to go to trial. I mean, and at least attempt to clear his name. He's going to appeal. Now, of course, I think he spent $2 or $3 million on legal fees. So there's always that.
Yeah.
But really, I don't know. I want to be really careful where I go with this because, again, just because, yeah, I don't want to really come across as if I'm cheerleading for a particular side in that case because it's not really appropriate or warranted. Do you know what I mean?
Yeah, I don't know enough about it to have a comment on it. I did want to ask, I know you were you headed to Tampa? Was it today, yesterday, tomorrow?
It was today. I was there for 9 to 12. I did a live stream about it already.
I was in class earlier today teaching, so I haven't had a chance to look at it. I have to jump on your page when we're finished and take a look at that and see if I can get updated on that.
Yeah, I already put chapter breaks in there and everything. It was fascinating. It was fascinating. David Miscavige's attorney, Monique Yingling, was there, the one I call Blinky McBlinkface. She was there. And just so everyone knows, this is the attorney that Mike Rinder in his book wrote about where, you know, Mike Rinder has been sitting there next to Monique Yingling when David Miscavige would call Mike on the phone screaming at him. And Monique could hear David Miscavige. And she even said to Mike, why does Dave talk to you that way? You don't deserve to be spoken to that way. You're a good man. You know, you work really hard. Nobody should speak to you that way. And I mean, what a weird position for a non-Scientologist attorney to be in, to be like representing David Miscavige personally all these decades, to know personally all these characters, you know, in this play. Mike Rinder, Marty Rathbun, David Miscavige, everyone. What a weird thing, right? You'd think that Scientology would at least have its own in-house lawyers doing the heavy lifting, and yet they have Monique Yingling, a tax attorney, who does all their dirty work.
You know, sometimes even if you don't like the area of law, if you've got a pretty steady cash flow, that may be what backs up those other areas of law that you enjoy more, but maybe aren't as lucrative or profitable to the firm. We call those rainmaker accounts. They're miserable, awful accounts to handle, but they pay on time and they pay copious sums of money. So you just deal with their crap because that's what makes payroll.
Yeah, I'd say Scientology is definitely a rainmaker account. That's for sure. All right, everyone. I think that's everything we've got on this. So at 5:30, I'm going to be speaking with a gentleman here. I'll introduce him to you when we go live. But he's a retired chief of police. We're going to be talking about the letter that Leah Remini published that she gave to the LAPD to deliver to Shelley Miscavige back in 2013 when they did their wellness check on her. And we're going to discuss a whole bunch of stuff surrounding that. So tune in about 30 minutes if you want to see that live. Anything else, Zach?
I don't think so. I'll continue to watch Twitter. As soon as I hear something, I'll let you know. We'll see if we can get a video out.
Awesome. Hopefully, guys, we'll be talking to you soon. Stay tuned. See ya.